What if copying just 11,000 lines of code could trigger a decade-long legal battle and put billions of dollars on the line? And what if the actual issue wasn't the code itself, but the structure behind it? Because that's exactly what happened in Oracle and Google, one of the most important intellectual property cases in modern tech. And the reason it matters is simple. This isn't just a big tech issue. It's a blueprint for how IP risk shows up in everyday software and digital businesses. Hello and welcome back to Elise Explains IP, where we break down intellectual property in a way that actually makes sense for businesses, owners, founders, and advisors. I've just returned from the INTA annual meeting in London, and I've got a slight case of the conference crud, so please excuse any croakiness in today's episode. Today, we're unpacking a case that completely reshaped how the industry thinks about software, APIs, and copyright. We'll cover what happened between Oracle and Google, why APIs became the centre of the dispute, and most importantly, what this means if you're building software, platforms, or digital products. So, what happened? Google was building Android, and they had one key challenge: to get developers to adopt it quickly. And the fastest way to do that was to make the environment familiar, which meant using Java. At the time, Java was owned by Sun Microsystems. It was widely used and well understood. Google tried to negotiate a license agreement, but those negotiations failed. So they made a strategic decision. They wrote their own implementing code, or API, but they copied the structure, the sequence, and the organization of certain Java APIs. In simple terms, they rebuilt the engine, but they kept the same dashboard and controls. And then Oracle acquired Sun Microsystems, and the dispute escalated into litigation. So, what was actually copied? This wasn't a straightforward copy and paste situation. Google copied around 11,500 lines of declaring code, the names of the functions, and the way those functions were organized. This allowed the developers to use familiar commands and transition into Android without starting from scratch. From a commercial perspective, it made perfect sense. From an IP perspective, that's where things become complicated. The case turned on a deceptively simple question: can the structure of an API be protected by copyright? An API is essentially a set of rules for how a software interacts. It's a way for systems to communicate across various different platforms. Here's a useful analogy. It's like a menu in a restaurant. It tells you what you can order and how to order it. Oracle argued that the structure involved creative choices. It wasn't just purely functional. Therefore, it should be protected by copyright. On the other side, Google argued that this was much more like a system or a method. It was necessary for the interoperability between platforms. And so even if it was protected by copyright, their use was fair use. And this dispute ran for over 10 years. At different points, Google won. Oracle won. Decisions were overturned. Appeals were continued. Until finally in 2021, the United States Supreme Court stepped in. But instead of answering the big question directly, they took a different path. The court did not definitively decide whether APIs were copyrightable. Instead, they assumed they could be, and focused on the fair use argument. And they ultimately ruled in Google's favour. The reasoning was grounded in the commercial reality of how these systems worked. They looked at the purpose and character. Google used the APIs to create a smartphone platform in a new and different context, which was considered to be transformative. They looked at the nature of the work. The API structure was partly creative, but it was heavily functional. And they looked at the amount of code used. Although 11,500 lines sounds significant, it was a small portion of what the overall system used, and it was limited to what the developers needed. They also looked at the market impact. The court found that Android didn't replace Java. It created a new market. Expanded the reach. So let's bring this into some more familiar setting. Imagine a SaaS business building a new platform. The development team says, let's model this on an existing platform. It will make adoption easier. And so they do replicate the structure of the system, use similar naming conventions, and mirror how users interact with it. However, they write their own code. From a business perspective, this feels very efficient. But from an IP perspective, the question becomes, have you taken inspiration or replicated something protectable? And that line isn't always obvious. A common assumption is, we didn't copy the code, so we're fine. But this case shows that's not always true. What mattered here wasn't just the code, it was the structure, the organization, the logic of interaction, and the nomenclature. So, even if something is rebuilt from scratch, you can still carry IP risk if the underlying structure is replicated. Google ultimately won their case, but it is important to look at what was involved. Over 10 years of litigation, enormous legal costs, and a highly uncertain outcome. I'm not sure I'd like to rely upon the US Supreme Court making the same decision today. And critically, Google had the resources to run that fight. Not every business does. In fact, most businesses don't. So relying on the, we think this is fair, or we'll deal with it if it becomes an issue later, isn't a strategy, it's a gamble. Before we go further, there's an important point here, especially if you're operating outside the United States. Because cases like Oracle and Google can create a false sense of comfort. You'll hear that Google relied on fair use, but fair use is a United States specific concept. In the US, it's a broad and flexible doctrine. The courts will assess the overall fairness and can use it to adapt to new technologies. That flexibility is what allowed Google to succeed. In countries like Australia and the UK, we have fair dealing, not fair use. And it is a much narrower exception. It only applies to specific purposes, like research or study, criticism or review, reporting the news, or parody or satire. If your use doesn't fit into one of those categories, the defense simply isn't available to you. And why does this matter? If you're building a commercial product, replicating a structure and using familiar systems and accelerating the development is very unlikely to fall within a fair dealing exception. A simple way to think about it is the US approach is this fair overall? Whereas the Australian and UK approach is, does this fit into a specific category of exemption? And if the answer is no, the risk increases significantly. Google's outcome is, firstly, jurisdiction specific, it's resource dependent, and it's not easily replicated, which reinforces the broader point. Legal defences are uncertain and expensive to rely on. If this issue arises in your business, the consequences are very real. 1. Investor risk. Questions around ownership of code and IP can lead to a reduced valuation or a delayed or failed deal in terms of financing. 2. Forced rebuilds. Redesigning systems and rewriting core functionality will cause significant cost and delay to any product you've got underway. 3. Licensing pressure. You might be forced into a license agreement or into paying retrospective fees for those time that you did use it. 4. Commercial disruption. Delayed launches and operational strain, which will increase the reputational impact of such a claim. So what should you actually do? Number 1. Be deliberate in design. Are you creating something original or modelling it on an existing system? 2. Audit what you rely on. Is it the frameworks, the APIs, or is it a third-party system? 3. Treat the structure as IP. Identify what gives you an edge and document how your system works. 4. Address risk early. It's far easier to fix at a design stage than it is after you've launched. 5. Get clarity before scaling, especially if you're raising capital, expanding, or commercializing your platform. Oracle and Google isn't just about APIs. It highlights a broader issue, the gap between how businesses build and how IP law views what's being built. Because often, the value isn't just in the code. It's in the structure, the system, and the user experience. And those are exactly the areas where risk can quietly sit. So if you're building software, platforms, and digital products, and you're not entirely sure where your IP risk sits, that's something worth addressing early. You can book a strategy call with me via the link in the show notes. And it's much easier to protect something that you're building now than try to untangle it later. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.